Hello everyone, thank you for joining me today on the Activist Lawyer podcast. I am delighted to have Franck Magennis join me from London. Franck works with the Garden Court Chambers and is a barrister. He was born in Dublin, raised in 6 counties, and was called to the Bar of England in 2016, practising public, civil and criminal defence. His work centres around challenging rights breached by the British and other states, employers and landlords. He has particular expertise in legal claims relating to various aspects of the Palestinian struggle against Israeli colonialism, apartheid and genocide. Now, we do discuss a case that really brought my attention towards Franck's work, which is around an asylum application for a Palestinian citizen of Israel. And I mean, it's an unprecedented case that we go into in a little bit of detail, wherein the Home Office eventually granted Franck's client asylum. And we talk about, the reasons why that happened, and Franck shares his opinion on all of that. But I think it's a really interesting conversation. I hope you enjoyed. I really took away a lot from this conversation today. I was really inspired by Franck and his work. And I think it's very insightful and very encouraging for a lot of listeners who might like to follow in his line of work. And I think you'll take away a lot from it as well. So thank you for listening, as always. I am delighted to be joined by barrister Franck Magennis, who joins me via Zoom from London. Am I right? Or
That's right, yeah. Great to be here. Thank you for having me.
No problem at all. Well, look, we'll get into it. And I suppose the first thing I'm interested in is really just a little bit about you and how you fell into law or decided to become a barrister. Who or what inspired you?
So I would say that I obviously grew up in the north of Ireland, and there's a very political upbringing, I suppose unavoidably political in that context. And so I had ideas about, colonialism and all the rest of it before I moved to England. And I moved to England when I was 16 and studied history at university at the age of 18. I studied in London at the London School of Economics. And it was during the course of my history degree, I had intended to just sort of become a musician and have this very sort of hedonistic lifestyle. But in the course of doing my undergraduate, I became very radicalized around this issue of Palestine. I think that for a lot of Irish people and people who are committed to the idea of Irish unification, people who, like myself, oppose the colonization of Ireland, there's a very intuitive sense of solidarity and an intuitive sense that there's a similarity between what Palestinians are going through and what we're going through. And so I became very actively involved in not only studying the conflict formally in the course of my undergraduate, but also I was very involved in the LSE-SU Palestine Society. And so we engaged in this kind of increasingly militant forms of activism, I would say culminating in our occupation of the largest lecture theatre in LSE in 2008, 2009, when Israel started bombing Gaza. And so I think that radicalized me, and then I became close with a lot of very inspiring Palestinian students and specifically Palestinian law students. And it was mostly through speaking with them and facing the prospect of graduating from a history degree without a clear idea about how to sort of advance my commitment to the Palestinian struggle, that they persuaded me, like, bluntly, they were sort of like, look, mate, you should just become a barrister and start prosecuting Israeli war criminals. Wow. And so that was my naive plan. It was really no more deep than that. It was that I could see that the Palestinian struggle was urgent. I felt a very intuitive and profound sense of solidarity with what Palestinians were going through. And I wanted to contribute to the struggle in some way. And I suppose the other thing then is that my politics were developing. At that time, I suppose I would have still identified as some kind of social democrat. And it was in the course of my 20s that I became more and more my politics became more and more coherent, and I suppose there was a process by which I embraced communist politics, and I would say it's my communist politics that sit at the core of my approach to law, and I sometimes describe it as my attempt is the attempt to subordinate legal practice to a prior political strategy. So I sort of sometimes describe myself as being a communist first and a lawyer second.
Brilliant. And obviously, I mean, the bulk of your practice, I think the majority of your work focuses on Palestinian issues. One case that really struck me that we'll talk about a little bit later is an immigration matter. But I'm wondering, what other type of work are you seeing coming through at the moment in terms of, your practice and the objectives that you want to achieve?
Well, so I should say I kept my practice very broad after I was lucky enough to get tenancy at Garden Court. Mm-hmm. There's this bizarre freedom that comes from being a self-employed tenant barrister. You can sort of do what you want and no one can really tell you no. Mm. And I think it's always difficult to see yourself clearly, but I think I got a reputation for being someone who just kind of caught the ball. Like, people would throw random cases at me, sometimes in areas that I'd never done before. And I would just jump in, often looking back on it at the deep end. Yeah. And then speak to lots of colleagues in chambers. I'm very lucky to live to work at a very collegiate chambers that has a very collective attitude. Everyone's very generous with their time. And so when I found myself doing a new area, I would just speak to some of the most senior barristers and silks operating in that area, and they would just bestow all of their wisdom on me. And it made me feel much more able to dive into new areas as if I wasn't doing it by myself. Mm-hmm. And also I was just very shameless about calling senior colleagues and saying, hi there, I'm completely out of my depth, what do I do? And so the consequence of that is that I've ended up with this very broad practice where I do most of the things, other than family law, I think I do most of the things that Garden Court does. Mm-hmm. And so what that means is that, thankfully, it means that I'm able to keep my practice very responsive to what comrades need, what the movement needs. And so a lot of people just have my WhatsApp and they'll come and say, this issue has happened, and I'll try my best to jump on it. Yeah. And to wrap my arms around it. And the other thing is that I'm public access qualified, right? So you don't need a solicitor to instruct me. And though obviously I prefer working with a solicitor, it's always preferable to be working with a solicitor if you can. Yeah. When stuff comes to me really urgently, or when stuff comes to me that people are struggling to find a lawyer to take on, mm-hmm. and the bottleneck seems to be a solicitor, it means that I'm in a position to just kind of, as I say, just jump on it and wrap my arms around it. So the consequence of that is that my practice often pivots to meet the needs of what the movement seems to be coming to me with. And what people have come to me with since October 7th has been a genuinely staggering number of employment tribunal cases, as well as professional regulatory cases involving people who have criticized what the Israeli regime is doing in the name of its Zionist ideology, people who've named and criticized Israeli apartheid or genocide. So people getting fired from their jobs, Palestinians and Palestinian allies being told that they need to remove Palestine badges and other visible signs of Palestinian identity. These kinds of employment tribunal and regulatory cases have been the mainstay of my work since October 7th. As I say, I've also been doing a lot of immigration cases. Yeah. But the strange thing that happened, and I talk about pivoting, right? I had a lot of clients from Gaza who had claimed asylum. I had something like 8 or 9 clients prior to October 7th. And then what happened was, obviously, all the violence started kicking off. The sheer scale of the violence became such that one by one, my Gaza clients, their cases were settling because the Home Office was offering not just humanitarian protection, but asylum. And so my immigration practice sort of disappeared within the space of a few weeks because my main focus had been representing people from Gaza. And so, as I think we'll come to, I was left with just one substantive immigration case, which was this Palestinian citizen of Israel. Mm-hmm. He was the one asylum client I had who didn't get asylum. And then I pivoted towards doing stuff to do with, as I say, the employment tribunal, because that seemed to be where the most urgent struggle was at. Yeah. And then, I mean, there's an ongoing case in the press, which I shouldn't comment on because we've not had judgment in it yet, but you'll see from the press that I was just in a 2-week trial representing 2 Muslim women who criticized Israel before October 7th, but the case just recently came to trial. And so my practice now revolves considerably around that kind of case. In the wake of Professor David Miller's case against Bristol University, where he successfully showed, him and his team, I understand it was Zach Samor, a formidable British Palestinian barrister who argued that case. Yeah. And as you know, they successfully showed that anti-Zionist belief, or specifically Professor Miller's anti-Zionist beliefs, were capable of protection under the Equality Act. So in the wake of that staggering judgment, it's cast a very long shadow. And now anyone who criticizes Israel or Zionism in a work context has a much firmer footing when it comes to trying to challenge those decisions. And that's been what I've been focusing on.
Brilliant. And just on that employment matter, I mean, the bar is quite low in terms of it's even, as we've seen in the press, and we'll not mention any cases, but there is a one out there at the moment where even somebody, for simply calling a ceasefire, has been sacked.
It's genuinely atrocious. The worst case I've seen, there's a woman who was very active about taking her case to the press, and so you'll be able to find press all over about this. But what happened in that case was that her husband is a Muslim woman in Oldham, and her husband was trapped in the Gaza Strip in the ongoing genocide. And so she was obviously completely beside herself. She was, I mean, I just can't imagine what she was going through. And instead of supporting her, her employer summarily dismissed her, sacked her on the spot, in what I think it's fair to say is one of the most egregious examples of unfair dismissal I've ever seen. And so obviously you hear about the worst cases. Presumably there are good employers out there who recognize that when they've got, Palestinian employees or employees who are in some way affiliated to Palestinians or just deeply moved and grief-stricken by the violence and the genocide that we're still witnessing. Some employers have reacted in a positive and sensible way, but the most egregious, I think it's a crisis. I think we have a free speech crisis when it comes to Palestine. And at the risk of being a bit blunt and making myself unpopular, I think it extends to the way that a lot of lawyers argue these cases. I think, like, without naming any names, it's been more than half a decade now that I've been advancing various types of case and speaking at events and so forth to do with the Palestinian struggle. And as we'll come to, I work closely with Al-Haq. I was in Ramallah for 3 months in 2019 working as a special visiting scholar at Al-Haq. So I have this a connection to the struggle, and I see how Palestinians view it because I spend so much time talking to them. And then you come to a place like London and it's like black is white, up is down. And, just to take one example, when it comes to advancing Palestinian asylum claims, to me, it is absolutely obvious that we should be going into court, going into the tribunal and saying there is copious evidence that Israel is governed by an apartheid regime. It's a regime that's institutionally hostile to Palestinians. It views them as a demographic threat to its project of establishing a Jewish racial majority in Israel. Of course, there is a real risk that if you return a Palestinian to the jurisdiction of that regime, that they're going to be persecuted by it. And yet it is very, very difficult to find a solicitor or a barrister in England who will make that argument. It's a blindingly obvious argument, right? You think about South African apartheid. If we were, for the sake of argument, in the early 90s, before the collapse of that regime, and you're representing a black person, a black African who's facing return to South Africa, it would be negligent not to advise them. You have an argument here. You have an argument that the regime systematically discriminates against people of your race. And yet, because of fears that they'll be accused of anti-Semitism, because of fears they'll antagonize the judge or whatever else, I've had a number of excuses over the years when I've said to people, you need to advise your clients of this. People often shy away from doing it. So it's a real problem. And I think it's a nettle that we need to grasp, and we need to be courageous or even fearless and properly go into court and advance these arguments about what's actually being done to Palestinians as we speak.
Yeah. And I mean, on that point, I wonder then how you feel about the Home Office's response in that particular case that you worked on and others where we didn't get to court, we weren't able to advance that far. I mean, do you think it's a good thing, or would you like to have, brought that case to its fruition?
I feel conflicted about this. I think that it's interesting to compare that. So you're talking about the case that was concluded in March. Yeah. So I represented a Palestinian citizen of Israel who, because I had very good solicitors who were on the same page as me, and because we actually listened to our client, he was staunchly anti-Zionist, he was a Muslim, and he was clear that he wanted to advance the case on the principled basis that we had outlined to him. Obviously, we offered him this kind of informed consent. We said, look, there is more than one way to win your case. It's a difficult case. It's not common that people with Israeli passports get granted asylum. If you want to do it the cautious way, this is the cautious way. If you want to do it the principled but sort of ambitious way, here's how you outline the arguments about apartheid. And then, of course, after October 7th, by the time the case was coming to court in March, we also had the benefit of the 26th of January ICJ judgment, which was saying this is plausibly genocide. And I should say as well, people thinking about running these arguments, that judgment's very helpful, and we included it in the bundle of evidence in this man's case. And it's helpful for a number of reasons, but in particular in an asylum context, there's a risk that you'll get faced with this criticism from the judge or from the Home Office. Why are you asking me to make findings about whether or not genocide is happening, whether or not apartheid is happening? These are concepts that come to us from international law that I'm not here to decide. I'm not here to decide whether or not Israel's committing a genocide. And what we say in response, obviously, is how can you decide whether or not someone's going to face persecution if you don't make findings about whether or not the state is engaged in genocidal violence? Yeah. And so you end up with it opens this whole can of worms. I think it's possible, it's very rare to get a Gaza case these days because even the British Home Office will seemingly grant asylum to them. But there are a few still knocking about. I suspect it's just bureaucratic oversight that's not resulted in them being resolved. But for the sake of argument, if those cases were to come to court, it's entirely possible, in my view, to argue that indiscriminate violence, as that term is defined for the purposes of humanitarian protection, if that indiscriminate violence is genocidal, it's also arguably persecutory violence, right? And so that's what we obviously Palestinian citizen of Israel wasn't facing the brunt of the genocide because he has an Israeli passport. But I think when you ask, would it have been better if it went to court so that we could have got a judgment and then use that to sort of persuade judges in other cases? I think it's useful to contrast it to what happened in a similar case, but that happened several years previously. So we went to court in 2021 in Manchester, and we were representing anti-Zionist Jewish Israeli asylum seeker. He was terrified that he was going to be conscripted into the Zionist occupation forces and forced to commit war crimes against Palestinians, basically. And so it was kind of one of these conscientious objector cases. And we advanced his claim on a number of different bases, including that his anti-Zionist beliefs were a political opinion for the purposes of the Refugee Convention. And what happened in that case, it was one of the most bizarre things I've ever seen in my entire practice. I submitted a skeleton argument that ran close to 30 pages that opened with a quote from Benjamin Netanyahu saying something to the effect of Israel is the state of the Jewish people and the Jewish people alone, right? Just making absolutely clear how naked the racial discrimination was. And saying, look, it's an apartheid regime. At this point, we already had several expert reports. And I sort of said, look, how can you decide whether or not an anti-Zionist Jew is going to face persecution without making findings about whether or not there's an apartheid regime whose animating ideology is Zionism and which is systematically hostile to anti-Zionist people who criticize it? And he wrote in response, took him 3 or 4 months, we had to complain about the delay in the judgment. He wrote a judgment that did not mention the word apartheid once. Okay. It was, again, it's like black as white. Yeah. It's absurd. How could you ignore the central basis of my argument? Now, we didn't have that in the case of my Palestinian citizen of Israel client because, as you say, it didn't make it to court. The day, less than 24 hours before we were due in the hearing, we received confirmation from the Home Office that they were to grant asylum. They were withdrawing the appeal, that they were withdrawing the decision that was being appealed and with a view to granting asylum. So it seems to me, obviously the situation had changed massively. We'd had 6 months of genocide by that point. And they were terrified, I think, that they'd get a judgment against them saying, they'd get a sympathetic judge and that he or she would say, we agree with Mr. Magennis, it is apartheid, it is genocide, and we're granting asylum on that basis. But in some ways, the damage was already done because the case got international press recognition. Exactly. Journalists from Japan and the US and so forth were contacting us saying, what's the significance of this case? And clearly anyone in any jurisdiction can say, it's the Refugee Convention. Yeah. So it's got global application, and in principle, any Palestinian citizen of Israel, or indeed any Palestinian facing return to the jurisdiction of any part of the British mandate can make these arguments. Yeah.
And I mean, while it's in their best interest. It was in their best interest to do that rather than have a judgment, as you say. But it's really unprecedented, isn't it? The way that they went about that, particularly given that they are and still are a staunch ally of Israel. But as you said, the key word there is apartheid. And that's the word that they wouldn't have wanted a judgment to mention that, as you say, if it was a sympathetic judge. But I'm wondering, does the recent case, the advisory opinion of the ICJ around Israel's policies on the occupied territory, which is in effect, it declared that it was effectively apartheid. Do you think that will have a bearing on such cases coming forward? I know your case was before that happened. Absolutely. It's difficult to overstate, the
importance of that ICJ advisory opinion is going to cast a very, very long shadow. It's just incredibly persuasive. We already had all this, Amnesty, Human Rights Watch, and all the rest of it, but those are persuasive, but it's not binding legal authority. The ICJ advisory opinion is a real game changer. Yeah. It seems as though there's now, we're still sort of taking stock, aren't we? It's so recent, and the shock waves are still being felt. But absolutely, as with the ICJ judgments in the South Africa case, I've found it in a number of different contexts incredibly helpful to just go into court and include that in my bundle, including in the employment tribunal, right? You're having an argument about all this Granger stuff. Are the claimants' anti-Zionist beliefs worthy of protection in a democratic society, all the rest of it? And you get to point at an ICJ judgment, which cites 3 of the most senior Israeli government officials saying what seems to be openly genocidal things about Palestinians. It just helps you to be able to say that's Zionism. It's this disgusting, nakedly racist ideology, and this is the state that's enacting Zionist policy, and it's seemingly genocidal, and certainly it's apartheid, and it's an illegal occupation. And so it's good to be anti-Zionist, isn't it? That ends up being really helpful, even in an employment context, right? And so the ICJ judgment, I'm still processing it, but it just makes it so much easier to go into court and say, well, who can really seriously deny now that it's apartheid? And then as far as the British government's position on it is concerned, we had this come up in some of my employment tribunal cases. When you're arguing over the question of anti-Zionist belief and whether it's worthy of protection, what the other side, the respondent, as they're called in the employment tribunal, will often say is, oh, well, the UK government supports Israel. And then you'll get into this stuff about the correct definition of anti-Semitism, right? They'll say the UK government supports the IHRA definition of anti-Semitism. And it's very easy to simply respond and say, well, look, I know that the judge hearing this case is employed by the same state, but the fact remains that South Africa, its apartheid regime was backed to the very last minute. The 2 states that backed it to the very end were the UK and the US. And so what do we actually learn from the fact that the UK is yet again supporting an apartheid regime? Not that much. History tells us that they're very willing to do that, but that by itself doesn't tell us really anything at all about whether or not we're dealing with an apartheid regime. And so bypassing that really disgraceful policy of the UK government is easier when you are able to point to the ICJ and say, well, the UK government might be ignoring it, but the highest court in the world has just said it's apartheid. So who can credibly disagree with them? It's very, very helpful advisory opinion.
So Frank, as an immigration solicitor, practicing for years, north and south, doing a little bit of asylum, citizenship, all the rest. I was able to help a large number of refugees who were fleeing Ukraine and had secure, safe passages to both Ireland and the UK. I could assist many families with that, and that was great. But what wasn't great and what was absolutely infuriating was the fact that I had to basically, or that I didn't have to, but the routes that were open for my clients in Afghanistan, for example, were immediately closed. We know that numbers had dropped in asylum from other countries as well. So any of my colleagues that were working in immigration at the time could notice and could see what was happening here. I'm just wondering what your thoughts are on this kind of application of double standards across the UK, Ireland and EU countries when it came to the war in Ukraine and perhaps other crises around the world, and what we're seeing happening in Gaza and in Palestine when people so clearly need protection.
You're absolutely right that it's racist is what we should call a spade, right? And there were all of these really shocking news correspondents and people just openly coming out with saying the quiet part loud, right? Whenever Russia did invade Ukraine, people saying like stuff to do with the racial characteristics of the Ukrainians who were suffering as a consequence, right? Saying, look, these people, there was a very infamous clip, right, that went viral about a correspondent saying these people have blonde hair and blue eyes, which is so on the nose, it's almost like cartoonishly racist, right? It's like these people don't look like what you expect a refugee to look like. And so it was clear from the start that, and this is no criticism of Ukrainians, it's not Ukrainians' fault that they have certain racial characteristics. We should all be clear about how the stark contrast that you've identified tells us something about how contemporary racism operates. So we have this good migrant, bad migrant distinction, which sits at the heart of asylum law and the border more generally, right? And so I think we need to interrogate that. And I think the Ukraine example shows us how it is possible when human need is actually taken seriously, because the people of Ukraine needed assistance. it was entirely possible for governments around the world to very quickly mobilize in response to that need. Okay. Mm-hmm. And it reminds me, to be honest, of what we saw in the pandemic, where homelessness, which is treated as this fact of nature, there's nothing we can do about it. They just need to be homeless people. Yeah. Sorry, there's nothing we can do about it. And then suddenly, oh no, there's a risk that failing to solve the problem of homelessness is going to result in the spread of this virus that affects rich people as well. And suddenly, like that, all of the homeless people were housed in hotels and other accommodation overnight. So we can solve these problems. We choose not to because we live in a system that is designed by people who benefit from failing to solve those problems. And so I was also saying, I think that the distinction you've identified is racist. We should name that distinction and acknowledge that it is racist. And yet I do think that more and more people can see just how stark the disparity is. And it's coming up a lot in my employment tribunal cases because you have these comparators, right? You have to show that an anti-Zionist, someone who shared a Palestine flag or something pro-Palestinian, gets horrifically criticized, gets fired, gets gross misconduct findings against them or whatever else. And it's very easy and intuitive in the tribunal to point to not just hypothetical comparators, but actual comparators, because we'll submit in the bundle all of this flurry of evidence talking about the company themselves making statements of solidarity with Ukraine. And then the witnesses just fall apart under cross-examination when you say, well, hold on a second. So we're allowed to say Russia invading Ukraine is wrong. But if we say Israel invading Palestine, occupying it for half a century, that's a problem, is it? So I think more and more people can see just how stark the disparity you've identified actually is. And more people are kind of calling it out. But I suppose the other obvious point, so in addition to interrogating the system as a whole and saying, look, this good migrant, bad migrant distinction has to go, in addition to saying that more and more people are speaking up and saying, hold on a second, why are Ukrainians these fully human people who deserve their needs to be recognized and met, but Palestinians are these kind of subhuman untermenschen and they can just be massacred in their tens of thousands and we do nothing about it? I also think that the obvious reason for this is just pure politics, right? UK is a staunch pillar of NATO. NATO supports Ukraine to the hilt with massive amounts of military aid and diplomatic aid. NATO also supports Israel. Israel is a key NATO ally. And that's the long and short of it. Whenever we're on the side of the people doing the invading, whenever NATO is on the side of the people doing the invading, then the people who are experiencing this obscene violence aren't fully human and can be discounted, as we're seeing in the case of Palestine. But when the person being invaded is a NATO ally, then suddenly they're fully human refugees and everyone needs to, quite correctly, respond to their needs. So I think that's the long and short of it, is that the UK is utterly hypocritical, but it's to be expected because it's not a principled actor. It's a capitalist, imperialist hegemon that does what its interests dictate, even if that forces it to lapse into just the most staggering racist hypocrisy. Yeah.
And I mean, anybody practicing immigration in the last while would have noticed and picked up on the good migrant, bad migrant, as you rightly pointed out, and the system itself being incredibly racist, and it was incredibly frustrating, to work through that. But anyway, in terms of, we did touch on your work with Al-Haq. You worked as a research fellow in relation to international humanitarian law and international human rights and the question of Palestinian emancipation, which, I guess was a wonderful experience itself in terms of working on the ground with that organisation, who is involved in some litigation with GLN, the group that are bringing a case against the British government around weapons supply to Israel. In terms of talking about the British government again, but we have seen a lot of press around this recently, and Britain's alleged complicity in this genocide in terms of weapons supply, or weapons that are manufactured in the UK that are being used by Israel. Will there be an end to this? There's been a call on the government. We thought they were going to call an end to, or put an embargo on weapons supply, but there doesn't seem to be anything happening at all. What do you think? I mean, is this important that this is progressed rapidly, or what's the feeling on the ground?
Absolutely, it's important. And there is, as you say, this incredible GLAN case, and I think Al-Haq are involved with it as well, judicially reviewing the ongoing arms sales. I've sort of looked into it not in detail in the past, because I had this hunch that we should be challenging arms sales, and so did a lot of comrades and colleagues, and we've been sort of talking about it behind the scenes, saying, how would we mount this challenge? And you may remember there was a successful Court of Appeal challenge to the British government's arms sales to Saudi Arabia, which sort of laid the groundwork and established the principle that it is possible, even though, of course, the courts in these cases, their starting points, implicit or otherwise, is that, look, these are matters of national security, really. Yeah. You know, you're talking about high foreign policy. Who do you sell guns to and why? And so the courts are very, very reluctant to intervene. And yet, notwithstanding that reluctance, Saudi Arabia, of course, a staunch ally of the United Kingdom and NATO and all the rest of it, because of their conduct in the war in Yemen. And I think because of relatively technical reasoning, the Court of Appeal felt able to step in and say, no, actually, there does need to be some judicial oversight of these arms sales. So the groundwork was laid, and then law plays a function. Obviously, David Lammy has been the one who's talking most publicly about this, as he's the new foreign secretary. And I saw Philippe Sands Casey, who was one of the barristers instructed to represent, I think it was to represent the state of Palestine in the ICJ advisory opinion. He came out in The Guardian a few days ago saying, look, in the light of this advisory opinion and all the rest of the context, arms sales need to be suspended. Yeah. So it's absolutely clear that they should be suspended. I mean, that's just a matter of basic decency. You don't sell arms to people or to a state that's engaged in a genocide. That's just horrific.
And you don't call a ceasefire while you're supplying arms.
Yeah, exactly. I mean, the UK has a long history of, hundreds of years of horrific colonialist behaviour. So we shouldn't be shocked. But it does. I mean, I think the South Africa example is instructive. It's like countries like the UK and the US will cling on to supporting their ally until the very last moment, until it becomes completely unsustainable. But I do think that there is, despite the horror that's still unfolding as you and I are speaking, I do think there is cause for cautious optimism. I think that from where I'm standing, Zionism looks like it's in a crisis, and I hope and I suspect that it's a terminal crisis. I don't think that Zionism will come back from this. I think you look at the way that Labour MPs lost their seats to independents in a first past the post system, where it's exceedingly difficult to challenge the candidates from the main parties, and yet they lost seats. And a politician like Wes Streeting came within 500 votes of losing his seat to an independent advancing arguments about Gaza. Keir Starmer, who's the Prime Minister, I think Andrew Feinstein, who ran an independent campaign against him, lopped something like 11,000 votes off of his majority, right? Just completely gutted his majority. That's the reality of public anger around this issue. And I think that Labour, because of the ridiculous vagaries and mechanics of first past the post, Labour now has this massive landslide, but it's an incredibly low turnout, and it's a very, very fragile government. And so we're going to have 5 years of continuity, reheated Blairism or whatever. And if the left gets organised, I think we can do real damage to these apologists for genocide. And so to bring that back to the question of arms sales, I think that law plays a marginal function. I think the case that Gilan and Al-Haq and co are bringing is a very important one, and it can apply pressure to the government, and hopefully it will. But ultimately, it's one factor that feeds into what's ultimately going to be a political resolution. But clearly, we agree that, ending arms sales to Israel is absolutely urgent. And I suppose we just have to try to do what we can to apply pressure to make sure that eventuality comes about. But it's just very frustrating, as ever, dealing with the British government and their just willingness to apologise for the most obscene, racist and colonial violence.
Yeah, it's incredibly frustrating and infuriating to see that unfold. But as you said, you've a sense of cautious optimism. And our last guest, Miranda Cleland from the Defence for Children International Palestine, also referred to similarly to you in terms of on the ground in America, and seeing that there is this kind of cautious optimism that she felt as well in terms of meaningful change on the ground. But just, I suppose, with anybody listening, Frank, to you talking about your work, and I mean, you're committed both politically as well as finding legal solutions to tackling issues. If anyone's listening, would you advise somebody who wanted to follow in your footsteps or get into, I know it's, you kind of got into it organically as such, there wasn't a step-by-step process, but for any of our listeners who are interested in both politically and I guess following, the type of work that you do, what advice would you have for them?
Yeah, I think it's a really important question because approaching a career in law can be quite intimidating, and there's obviously a class aspect to it, right? Like people who come from middle class backgrounds, who have parents who went to university, whose sort of family and social networks include practicing lawyers, they'll just find it a lot easier to sort of segue into a career in law if that's what they choose. Whereas people from a working class background will often encounter this culture with which they're sort of unfamiliar and which is quite hostile to them. And I think that's particularly true of Irish people and people from other British colonies who tried to make it as a lawyer, specifically in England and Wales. Mm-hmm. You will encounter really obnoxious views about, the Irish struggle. It's just it's you have to wade through the obnoxious racism, sexism and classism of the British legal sector, which is, I think it's fair to say, one of the most reactionary parts of British society. There are parts of the English bar that are stuck in the 19th century, and you see it on the bench all the time. I remember when I was paralegal, seeing 3 different barristers in the High Court, 2 of them men and 1 of them a woman. And the way that the male judge's demeanor changed whenever, I think it was Philippa Kaufman, if I'm not mistaken, before she was a KC, and the way the judge's demeanor changed towards her whenever she started speaking. I mean, it's always difficult to say. Maybe it was the fact that some specific aspect of her case was what he didn't like. But my clear impression as a paralegal coming to the profession with fresh eyes, it looked to me awfully like unvarnished sexism. Mm. So you're going to encounter that. We did an event a few years ago as part of a group I was involved with called the Materialist Lawyers Group, which was a kind of crypto Marxist group. And the event was called something like, does pretending to ignore the entrenched racism, sexism and classism of the English bar help you get a job here? And there is this received wisdom that you sort of have to hold your nose and pretend that you don't see all of this obscene stuff happening right in front of your eyes. When I was getting qualified, I'm fond of telling these stories about how you would hear often senior judges saying outrageous stuff about the Irish struggle for unification and independence. And it got to the point where I realized a lot of these people in the English establishment are kind of idiots and they don't know what they're talking about. They live in this bubble where Irish republicanism is this bizarre, inexplicable, violent phenomenon that emerged out of nowhere. And you just have to prod them and their arguments fall apart because they've not had to think these things through the way that those of us who grew up in the north of Ireland have had to actually live this from a very young age, right? Like, where does this horrible colonial divide and rule strategy leave us? We had to learn these arguments very, very quickly from a very young age because the stakes were so high, and these coddled English judges often haven't had to experience that. So one part of my advice is that a lot of people, when I approach them, I approach practicing lawyers, I approach people who are slightly further down the path towards getting qualified than me. And most of them said, when I told them, oh, I want to become a barrister so I can prosecute Israeli war criminals, which was my motivation at the time, they said, oh, don't say that. Don't tell people in your pupillage applications, in your scholarship applications, don't tell them the real motivation. And I think that that was terrible advice. I think that you should be yourself. You should be humble. You should be, but you should be confident, and you should have integrity, and people will respect you for it. Even your class enemies and your political opponents and all the rest of it. If you go in and say, well, in my opinion, Israel's governed by an apartheid regime, I think what's happening to the Palestinians is devastating. And honestly, that's what's made me want to be a lawyer. I want to contribute, however marginally, to the process by which human rights come to be respected across the territory of historic Palestine, and Israel's apartheid regime is dismantled. They might be a bit taken aback. Some of them will be. Others will be like, fair play. That takes courage. It takes the kind of courage you want in a lawyer. So that's my first piece of advice, is be yourself and don't let some middle-class, Eton-educated English person or whoever else tell you that you shouldn't be who you are. I think there's a lot of second guessing. People imagine that, I also think people imagine there's less progressive views and less anti-capitalist views in the legal sector than there actually are. And so there becomes this self-censoring thing where we can't find each other because we don't talk openly about it. And that's why I think this podcast that you folks have curated and created is really important, because it gives us space to say, no, this is what lawyers actually think like. We might have to go into court and put on a certain professional facade, but behind that facade, when we're outside of court, we can talk much more openly about our true motivations. And then I suppose I have some reading suggestions. I think that there's an infamous essay by Duncan Kennedy, the Marxist Harvard law scholar, called Legal Education is Training for Hierarchy. And that had a really big impact on me when I discovered it in law school during my master's degree. Just a very good analysis of the way that law schools try to encourage people to defer to these obnoxious imperial capitalist hierarchies and what you can sort of do about it. And he basically encourages us to be critical and says, you know, there's a naive liberal conception of law that says it's this fair ideal, and if we just administer the ideal more rigorously, then justice will come forward. And then there's a more critical, realistic vision of law, which is that it's a sham that masks the claims and interests of the powerful, and that if we're to intervene on that terrain, we are on enemy terrain and we should act accordingly, right? There's another brilliant essay. I'm really interested in strategy. I think that a big problem that we face is that some of the most militant comrades operating today have very sophisticated and well thought through strategies. I'm thinking in particular of a group like Palestine Action, right? These very courageous guys who go in to directly materially challenge Elbit Systems UK Limited, which is a subsidiary of Elbit Israel Limited, right? These arms companies, their strategy is staggering. They're so courageous and they're having such an amazing effect on the struggle. And my impression is that what they need is lawyers who are as militant as they are, and who don't use legal, often quite grubby legal liberal tactics to smother a more militant anti-capitalist, anti-Zionist strategy. So reading around strategy is really important, so that you go into your burgeoning career with an actual strategy about what to do when law conflicts with politics, and to make sure that you prioritize politics over law, so that you are listening to your clients. What all too often happens is that the lawyer tells their client, no, you can't do that, when actually the correct advice is, well, you could do that, it would be risky, but here's the potential rewards. And that's effectively what happened in this case with the Palestinian citizen of Israel. Most lawyers would have said, no, you can't go into court and argue that it's an apartheid regime. And what we said was, look, there's two ways to do this, but if you want to, this option is available to you. This will be the risks, this will be the consequences. So reading about strategy, in particular, Rob Knox, who's a professor at Liverpool, I believe, has a brilliant essay called Strategy and Tactics, and he relies heavily on, you know, Lenin and Lenin's understanding of strategy, and he applies it to international law. So I would read Rob Knox's essay, because it's a great starting point for thinking about strategy and tactics. And then there's some other stuff on strategy. I mean, Marshall Gantz has this influential book called Why David Sometimes Wins, and I've been exploring that with a lot of my clients, right? Instead of just going in and offering them this very desiccated legal advice, going into them and saying, let's think deeply about what your actual strategy is, and then we can think about where law may or may not even fit into that. Because sometimes the best advice to a client is to say, you don't need law here. Law is not your friend. And then the other practical piece of advice I would offer is, I remember feeling a bit intimidated by practicing lawyers, thinking that they were these kind of untouchable people who were very, very busy, and that, you know, I couldn't really say anything to them without annoying them or getting in their way. I don't think that's true at all. As someone who's now the other side of getting qualified, most lawyers are very generous with their time and want other comrades to succeed in finding a way towards the legal profession. I'm very influenced by what Gramsci had to say about intellectuals, right? Like Gramsci, obviously, in his prison notebooks, talks about this idea that different classes, the feudal class, the bourgeois class, and the working class, has this process by which it generates organic intellectuals. And in some ways, I think the way for comrades to think of themselves, who are, you know, if you're thinking about a legal career, try to read up on what Gramsci had to say about intellectuals. Think deeply about what does it mean to be an intellectual that's organic to the class as it engages in struggle against its enemies, and then just reach out to lawyers who inspire you. Send them an email, send them a DM on Twitter, whatever it is, and say, hey, I'm thinking about becoming a lawyer, trying to find my sea legs. Can we get a coffee? Can we Zoom? Can I shadow you in court? And most people will say yes. I certainly, anytime I receive a message like that, I always make a point of responding and making time for people, because it's the way that I found my feet in this very difficult enemy terrain, as I've put it. And so I feel a sense of duty to the new generation coming through. So just be bold, send emails, be honest in those emails about your motivations. As I've said, don't, if you want to prosecute Israeli war criminals, whatever it is, say that in the email when you're approaching lawyers. And if they don't respond positively, if they act all haughty and arrogant, then that's probably a good thing. I would say a small number of people will act in that way, but most people will be very generous. And even if they disagree with you, you can just have a thoughtful conversation with them about your disagreements. Yeah. So yeah, just be mindful of strategy, read about strategy. Don't hide who you are, and don't defer to the obnoxious racism and sexism and classism and all the rest of it of the legal sector. And don't be afraid to reach out to people who are doing the kind of work that you want to do, and just ask relatively blunt questions about how did you get to where you are, and do you have any advice for me?
Yeah. Well, look, Frank, that's powerful advice and deeply encouraging for anybody who maybe, I suppose, wants to challenge the system and is afraid to take a step into the legal profession for reasons that you just outlined. So that's really encouraging. I think you probably have covered my next question as such, but I'm wondering about activism and the law. And you said there in some cases people don't need law, maybe they need activism and they need to push forward through another way. But in terms of making meaningful and real change, you are a lawyer, you work within, certain confines, and although you're interested in following other strategies and exploring other strategies that work, which is really, really important advice. But how do we make effective and meaningful change? How do we reach our objectives by using law and activism, or are they two separate realms?
I think it's a really vital question, and I don't have an easy answer to it. I think it's one that I sort of consciously or otherwise, I end up reposing the question almost every day in my job. I think we have to try and answer this question collectively, which is why I'm so grateful to you for creating this space for us to explore it together. I think it's a really vital question. Again, I would say reading is important because, I'm very influenced by this book by Paulo Freire called Pedagogy of the Oppressed. And he talks about how really to be emancipatory and to avoid domination and oppression, education has to be a dialogue of equals. And he effectively says you need to try to dissolve the student-teacher relationship and to recognize that we are all capable of teaching each other and learning from each other, and that he encourages us to engage in this kind of problem-posing dialogue. So education for him is not, he criticizes this banking deposit model of education, according to which the teacher has this commodity called knowledge that they deposit into the empty banking deposit box of the student's mind. He obliterates that and says, no, it's a dialogue between equals aimed at understanding the problematic nature of reality, right? So it's like, what is the problem here? Let's enter into this inquiry together about what is your problem. And he pioneered this in the context of illiterate peasants in Brazil, and there are all these approaches to how do we teach these peasants how to read, and the dominant approach was to go in and to be one more person telling the peasants what to do. You must learn this language, you must learn how to write and read. And what he said was, no, if you go in and you embed yourself in those communities and listen to what and engage in this problem posing dialogue with the peasants, you'll understand what their problems actually are, and then through dialogue they may come to see the way in which language, contracts, all the rest of it are being used to dominate them. And when they see that, then they'll be chewing your arm off saying, oh, can you teach me how to read this language? Because I can see how learning it is going to form part of the process by which I emancipate myself. So I have found that incredibly influential when it comes to thinking about my relationship with my clients. It is a very formal environment going into court and so forth, and there's all this insurance and the formality of who's instructed you and stuff. And so that can get in the way of attempting to apply Freire's principles. But I think we need to. I think we need to go into the legal profession with a view to dissolving the lawyer-client divide, as problematic as that might sound, and actually saying, I've taken to saying, we're all lawyers. Like everyone, and Gramsci says we're all intellectuals. In my opinion, we're all lawyers. What's a lawyer? A lawyer interprets the law and tries to avoid falling foul of it, tries to get the right outcome from underneath the legal regime that's dominating us, right? We're all stuck in these capitalist legal systems trying to navigate them together. So in some sense, I'm not trying to be too playful. In some sense, we are all lawyers. And I learn every day things from my clients, right? And so I don't want to be too critical, but I find myself feeling very out of place among lawyers, most of whom patronize their clients and think of themselves in these Freirean terms as the person with the knowledge that they need to put behind a paywall and give to their give to their client who has an empty head as far as knowledge of the law is concerned, right? I think that's obnoxious, and I think that we do something far more radical by fully humanizing our clients and admitting that we learn from each other. So that's one part of my answer to your question. You know, the other part is I touched on Gramsci. I think that I've noticed a phenomenon where people, 17, 18, 19-year-old people come into legal education. Maybe they're doing an undergrad, or they graduate from their undergrad and they think, I'm going to go and do a law conversion course and think about practicing law. And they have decent political instincts and they get into it for decent reasons. And then what they encounter is this deeply conservative profession, as I've said, one of the most reactionary places in British society, where just views that are completely unacceptable still somehow manage to go unchecked. And in that context, in that very, very conservative context, they come to imagine that, administering Tony Blair's Human Rights Act is the height of radicalism. And it's not, right? Like, you need only think about who passed the Human Rights Act to understand it's not a radical piece of legislation. It's deeply liberal. It's part of Blairism. It's part of the process by which the capitalist state reproduces itself. So we should be highly critical of it. But if we're surrounded by all these Tories, it's very easy to imagine that we're being incredibly radical just by saying, oh, I think that an asylum seeker shouldn't be returned to a country where he's probably going to be killed. So the way to avoid that problem of becoming complacent and thinking you're more radical than you are because you're setting the bar so low is to remain embedded in the movement. And it almost feels as though I have these two parts of my life. I have my legal profession, where I'm surrounded by, there's a handful of colleagues who share my politics. There's not many of them, but there are some colleagues who are engaged in a similar political project to me. But the legal sector, on the one hand, is a space where I feel incredibly out of place. I don't feel welcome. I'm often sneered at. I'm told that I'm some kind of terrorist sympathizer, that I should be, I've been dragged in front of my professional regulator by Zionist organizations who say that, make these outrageous, baseless allegations against me on the basis of my advocacy for Palestinians. So I feel, like I said, like I'm on enemy terrain when it comes to the legal profession. And then I have this other part of my life, which is like the movement, the comrades, where I'm plugged into these different militant organizations like Palestine Action, like various militant trade unions like United Voices of the World. And this distinction for me was made really stark when in 2019, after I came back from Palestine, I went to work at United Voices of the World for 6 months, right? So I was seconded to work as the head of their legal department. And the change was just so stark. I remember just feeling like, oh, these people don't view me as this like ridiculous, childish embarrassment. These people actually share my values, and I feel like I've come home, kind of thing. And I remember the first time I went to attend a disciplinary hearing, right? Because I was used to attending court. And so I showed up to this trade union disciplinary hearing in my capacity, not as a lawyer, but as a trade unionist, wearing a suit. And everyone in the office just like ripped the piss out of me. And they were just like, why are you wearing a suit, dude? Like, you're in a trade union now. Like, you don't need to act like you're some bourgeois, respectable guy. You can show up wearing a hoodie and they'll be more scared of you if you do that, because you have that confidence that comes from being part of the organized working class. And so I think what I'm trying to say is that it's something I touched on in my previous answer, but the most concise formulation I've come up with, and I think Rob Knox owes a lot. My analysis owes a lot to Rob Knox. He attended a conference that I helped to organize, again, through this Materialist Lawyers Group organization. And he spoke really compellingly on his panel about the way in which a militant anti-capitalist political strategy is often smothered by the law. And so that is, for me, the central problem. How do you pursue a legal practice in a way that is subordinate to a prior political strategy? And I think the way to do that is for people thinking about a legal career to join revolutionary and anti-capitalist organizations before or as they're approaching the law, and to be surrounded by comrades who are engaged in a ruthless criticism of the reality of capitalist, imperialist class relations, so that you have that prior strategy. And when it comes into conflict with what you're being asked to do in your legal profession, you are at least conscious, in the sense that Paulo Freire defined it, that there is a problem here. There is a tension between what my often very militant clients want to do and what the laws of this British capitalist state are telling them they are able to do. And it's our job as militant lawyers, as distinct from liberal lawyers, as lawyers who pass over that threshold into joining the movement, the anti-capitalist movement that wants to overthrow capitalist class relations. We have to enter into that dialogue with comrades from the movement. What is to be done when our strategies come into conflict with the reality of the laws that the British state has passed? And I don't have easy answers to that question, but I think finding ways to collectively pose that question as a precursor to collectively solving those problems together is, in some sense, what it means to be an anti-capitalist lawyer.
Okay, well, Frank, I mean, thank you so much for that advice. I think listeners will find it incredibly powerful and also really inspiring as well, and very encouraging for people who maybe are considering a career in law but feel conflicted in perhaps their activism, their political beliefs as well, and seeing it as a construct that might not be accepting of them. But your advice to be yourself and stand tall should hopefully encourage some of our listeners. And I mean, you've been so candid and so generous with your advice today and sharing your opinions as well. And I wish you all the best in your work around, especially the tribunal cases I'm particularly interested in, and also any of the immigration matters that come forward. I'd be interested in following that and your work in general. I have to say it was genuinely a really enjoyable conversation. I've learned a lot. I've taken a lot from today's conversation. I hope our listeners do too.
Thank you very much. I can't emphasize enough how vital it is, the space that you've created for us to have these important conversations together. I'm really, really grateful to you for creating this space for us to have this dialogue.
Thanks everyone for joining me today. If you like the show, please remember to share and leave a review if you have a moment. And you can also check out our website, www.activistlawyer.com, where you will see some blog articles written by our guests and contributors, as well as some fabulous Activist Lawyer merchandise.
This podcast was recorded in Granite Podcast Studio. Interested in starting up your own podcast but don't know how? Granite Podcast Studio can help. Record your podcast in our state-of-the-art studio, which is based in the heart of Newry City. Our studio has cutting-edge and user-friendly technology and can seat up to 4 people. We also provide an editing service for our team, using your guidance and editing notes to provide you with a flawless finished product, leaving your listeners wanting more. For more information on how you can get started, visit www.granitepodcaststudio.com.